Welcome to You Counsel. This is our fourth lecture in this series where we had initially posed the question whether any tort liability could arise from a wrongdoing in the virtual world. And we discussed this in our first three lectures. We talked about how the virtual reality operates and what is the kind of interaction that a real person can have in the virtual world, what kind of impacts could a real person experience from any conduct in the virtual world. We talked about the reality of damages or harm, especially the mental trauma that one could suffer because of the wrongdoing in the virtual world. And then in the third lecture, we talked about some of the aspects of tort of negligence. There were 5 elements of tort of negligence that we talked about, and we emphasized our discussion on the duty of care, which is sort of the most important point in the tort of negligence, especially when you're looking for a new duty of care towards a defendant. So we explored that, and in today's lecture we'll talk about the rest of the factors in the tort of negligence and see whether there is a real chance that a tort liability may follow from a wrongdoing, a tortious conduct in the virtual world. We begin our lecture with our usual disclaimer that this lecture is not legal advice. So if you have any specific questions regarding the issues that you may be facing, you should contact a lawyer or a paralegal or the Law Society of Ontario for a referral. We talked about the elements of tort of negligence. These are 5 elements. The defendant owed the plaintiff a duty of care. And as I said, we spent significant time in last lecture talking about whether there is a duty of care for the online virtual world providers, whether there is a duty of care for the person who uses an avatar to commit a wrongdoing to another avatar. Could there be a duty of care? So we discussed that in the previous lecture. The second element is whether the defendant breached the standard of care, and the standard of care is a reasonable person standard. We'll talk about that today. And whether the defendant's breach caused the plaintiff's injury or loss, which is causation, the injury of harm, whether that was foreseeable or not. And then finally, did the plaintiff actually suffer harm or loss? So let's go over these one by one. Standard of care, it's also called reasonable person standard, and it is defined as what a reasonable person would have done in those circumstances. So the circumstances means that specific act that we believe is the tortious conduct, is the wrongdoing. An example of this could be when a person sues a surgeon for not performing a surgery correctly, then the court will consider what would another reasonably qualified surgeon would have done in those circumstances. So the court has to first determine what is the standard of care that that person, the defendant, ought to have followed. And again, it depends upon, because it's a reasonable person standard, so the court sort of objectively looks at what would another reasonable person with the same qualifications would have done. In case of surgery, the court will determine what are, for example, the guidelines of the college, the regulatory college for the physicians. What are the guidelines? What is it that another surgeon would have done in the similar situation? And then determine whether the conduct in question, whether that conduct in fact breached that standard or not. So if a reasonably qualified surgeon would have done the same thing that this surgeon had done, then obviously the court will conclude that the standard was not breached by the surgeon. So there will be no tort liability. Now, in case of online gaming industry, virtual world, we were talking about Roblox. And so because Roblox or other similar gaming present itself as imagination platforms, so the question is, what would another reasonably imaginative platform, what kind of, what would they would have done in terms of the creation of that imagination platform? So restricting ourselves to Roblox, because Roblox presents itself as an imagination platform that targets as young kids as 6-7 years old, right? And so would a reasonable company that is creating an imagination platforms for young kids, 6-7 year olds, would they create an imagination platform that will allow for example, pornography to be shown to the young children? The answer would be no. Would it allow young children to be exposed to sexual conduct or misconduct in that imagination platform? The answer will be no. What would it allow, online bullying through virtual world? And the answer would be most likely no. So the question then, the standard of care when the court is considering this question is that if it's an imagination platform, would there be certain limits to that imagination platform that ought to be put in place? And that question is dependent upon who is the user of platform, what is the purpose of platform. This is not a platform for sexual games. It is a platform for children to play ordinary games, right? So those are sort of the things, and then the court will determine what would a reasonable company that would have created that platform would have done in similar circumstances. The next question is obviously, even if there is harm, was the harm actually caused by the defendant's breach, right? So in our example, and we took the example of that 7-year-old that experienced virtual sexual assault in Roblox while playing a game. So if the harm is the mental trauma, the question for the court to consider is that mental trauma, was that caused by the specific wrongdoing, in our case, the virtual sexual assault? Is that what caused that injury or loss? Because there could be other circumstances that may have caused mental trauma. The child may have been experiencing some difficulties at home. Maybe her parents are going through some difficult time. Maybe the child has experienced the loss of a loved one. Any of those circumstances. So even though there is trauma or harm, what actually caused that trauma is a question, because if the harm or trauma was not caused by the defendant's breach, then the causation is not established, right? And so it's a difficult question, especially when you're dealing with mental trauma and issues of mental suffering, right? Because it is easier to sort of show causation, for example, in a motor vehicle accident, where prior to the accident, your legs were fine, your arms were fine, but after due to the accident, like you suffered a broken bone or something, and that's sort of easier to show because it's visual. It can be shown by evidence that you were fine before the accident, and after the accident you have suffered this kind of thing. Even though causation itself can get complicated, but let's not get into that discussion at this stage. The point is that causation needs to be shown as an element of negligence in our scenario. The fourth element is foreseeability. In foreseeability, could a reasonable person foresee or anticipate the injury or harm? So was it just a freak accident, or is it something that could be foreseen? Can it be foreseen that if you conduct yourself or someone conducts herself or himself in such a way in virtual world, that conduct, that wrongdoing may cause real harm to somebody? Is that foreseeable, right? And foreseeability is an interesting thing. Foreseeability is based on common sense, but it is also based upon our experiences, right? So if you pose this question, or if you had posed this question 20, 30 years ago when the virtual reality was, just coming into existence, a lot of people may not have foreseen that the conduct of this nature may cause real harm. Some people may have anticipated it, but a lot of people may not have. So as we experience, or as we will experience more injury, more harm, unfortunately, it will be easier for us to recognize the foreseeability of the conduct and the harm, right? So foreseeability is also dependent upon our experiences. And another example that I can give you is with respect to toys, right? Now we live in an age where we have so many toys and all kinds of toys for children, and you will notice that the boxes have labels on toys, and it would indicate that certain toys are suitable for, let's say, children of 7 years and older, right? And it indicates or suggests that, number one, the toys may not be suitable because the younger kids, the toddlers, may not have the capacity to play with that toy, but also that the children, the younger children, the toddlers may experience some hazards, may risk, right? So for example, we know that if you give anything small size to a toddler, the first thing they do is they pick it up and they put it in their mouth, right? And so the choking hazard toys are an example of that, and so there are age restrictions on that. So now this choking hazard, this our understanding or foreseeability of this, that a toddler would pick up anything and put it in his mouth and it could cause choking, is based on our experience, right? Children, young children in various circumstances suffered these choking issues, and then the law became aware of the foreseeability of the harm, and which resulted in sort of, certain labels and warnings on these toys and our education on these issues. So foreseeability is again another element that needs to be proven with respect to the tort of negligence. Final element is proving damages. So we need to show to the court what was the harm or loss, and in our example the harm or loss is mental trauma or mental suffering. But then the next element is, how do you prove it? You have to prove that, and as I said, it is easier to show physical harm because you can visualize a broken bone, a broken finger, and the harm is easy to visualize. But in cases of mental trauma, even though courts have awarded damages for a long time on mental suffering and mental trauma, but they've always struggled with it because it is not easy to understand someone's mental trauma or suffering because it's not visual. You have to rely on medical evidence. You have to rely on circumstantial evidence. Another example that I can give you, for example, in one of the examples that we had given in our lecture 1, there was the 7-year-old child who was groomed in this online game, also in Roblox, through a third-party app, to send his sexually explicit images to other people, and so, but his parents recognized issues because the child was socially withdrawn from family activities. He was constantly withdrawn from that. So when you are showing mental trauma or mental suffering in those cases, then there's circumstantial evidence that you can bring, with inability to interact socially or isolation and all of these things. But it is possible to do that. Point is that regardless, whatever damages one person is claiming, at the end of the day, you have to prove those damages to the court to be able to get remedy from the court. So in conclusion, what we have done in these 4 lectures is we have sort of, I have proposed, and at least in that discussion, that wrongdoing in the virtual world, it is possible that it will lead to a liability in the real world because the harm is real. If the harm is real, then it is easy to foresee that that sort of conduct could cause those harm, because if the harm is real, then obviously it is foreseeable that this will cause it. So we've had that discussion, but that's not the end of discussion, because there are many defenses to tort liability, and this is where the rubber hits the road, because it is in those defenses that a lot of defendants will try to get away from tort liability. And one example of those defenses is contractual waivers. We have all seen those all the time, all around us. You go to a park, you sign a contractual waiver. You go to skiing, you sign a contractual waiver, which indicates that if you get injured in skiing, the ski resort is not liable. So these contractual waivers are pretty strong, and there's and they have a way for the defendant to avoid liability. Also, in the U.S., there is First Amendment in the Constitution, and there are cases that indicate that online gaming is considered an expression, and so they're protected under First Amendment of the Constitution in the United States. So what we'll do is we will cover these defenses in our next lecture and see what are the kind of defenses that are available to the virtual world providers and people who may use virtual world to do certain wrongdoings in the virtual world, what kind of defenses they may have, and then we'll discuss whether those defenses would make sense in the coming months or years when these issues will come forth to the court. So please stay tuned. We'll have another lecture shortly, and thank you for watching.